Welcome back to the Ultimate Mixdown. We have a special guest today. It's entertainment attorney Ryan Schmidt from Bowen Schmidt Entertainment Attorneys. And today he's here to talk all about copyright and ways that you can protect your music. Now, I'm going to preface with I am not a lawyer. Ryan is a lawyer, but he is not in a client-lawyer relationship just yet. And if you want to say any more to that right now, go ahead.
Absolutely. So the usual legal disclaimers is that this is general advice. Every single situation is different and can differ on any number of circumstances. So this is general music business advice. But if there's a specific situation, especially if you've been handed a contract or something like that, always have that looked over by an entertainment attorney.
Perfect. So just to give a little background, Ryan and I have known each other since we were kids. Our parents or our mothers were in Mother of Twins clubs. So Ryan's a twin. I'm a twin. Fun fact, I married a twin. And so lots of twins to go around. But we grew up in the same town, went to the same schools, and both have a passion for music. Ryan took that passion a lot further in going into the lawyer route. And now he's got a number of clients under his belt where not only is he helping them with legal matters, but he actually understands from the musician perspective. He's been doing this now for how long, Ryan?
I'm practicing for 6 years.
6 years. So very established. And this interview, we're going to basically be talking about Ryan, Bowen and Schmidt Entertainment Attorneys. And then we're going to talk about copyright and what it's all about. So Ryan, why don't you give us a little background on what you've been doing lately?
Well, first of all, thanks for having me. I was really excited for the invitation. Obviously, we go way back, and I even remember. I don't know if you remember. I think it was elementary school or middle school. Us jamming out and working on songs together and stuff like that. So it's coming full circle. This is awesome. So my name is Ryan Schmidt. For everybody that's tuning in that hasn't met me yet. And originally a singer-songwriter from New Hampshire, the Boston area. And I was doing that for a while, moved to Nashville, focusing on the songwriting career. And while I was there, I was presented with some contracts that weren't so great, that would have really messed up my career. A bunch of my friends were also presented with similar deals, like publishing deals and artist development deals, record label deals, that also would have messed them up and messed some of them up in a big way. And I've always had a passion for contracts and the legal side of music. So, very early on, people would come to me and say, "Hey, do you know what any of this means?" And I kind of had a sense of it, but I was really, really passionate about it, really interested in it. And I wanted to be kind of that watchdog or that advocate for artists. So while in Nashville, I went to law school at Belmont University, and that was an amazing experience having Music Row right across the street, obviously in a huge music town. My wife went to SCAD, Savannah College of Art and Design. We'd always wanted to get down to Savannah and really make some roots there, and that's where I teamed up with my now partner, Bo Bowen, who was doing corporate entertainment law, but largely in the film and television space. So when I jumped on board, I said, we really need to add music to that.
Definitely, man. So, with being down in Savannah, Georgia, does it mean that the types of advice that you're going to give depend on state laws, local state laws, or is it typically a federal copyright that we would be talking about today?
Well, I am only licensed in Georgia. I will say that I do represent clients all over the country and some outside of the country. And that's because the license really limits you from going into court. But if we're talking about negotiating contracts, you can have lawyers, all over the place looking at those contracts. And usually those businesses are New York, Georgia, California that are offering those deals. So the lawyers can be anywhere when we're talking about contracts. And the only difference is that you really see there, it isn't state contract law. It's really a matter of one line in the contract that talks about the jurisdiction, what state law applies. And that'll just change depending on who's offering the deal. but many of those contracts are going to be based on industry standards rather than specific state laws. There's plenty of areas of the law that vary greatly from state to state, family law, wills and trusts, that sort of stuff. But when we talk about contracts, it's pretty uniform. And especially when you talk about entertainment music contracts, there's a national standard. And then when you talk about copyright, trademark, those are all federal protections. So that's going to be the same in all 50 states.
Perfect. Well, thanks for joining in. We have a ton of value, lots of questions. So I think we'll get right into it. The first one I want to talk about is, what is copyright? I don't want to spend too much time on it because there's a whole universe out there, but copyright.gov, I believe, is the place to go. But if you would like to just tell us what copyright is, we can start from there.
At its most simple, copyright is a limited monopoly that you as the creator have in your creative work.
Okay, and when a lot of people talk about copyrighting their music, they're talking about registering their music for copyrights. So in that essence, they're trying to get certain protections from it. Could you talk about a few of the copyrights that cover musicians and musical works, and what types of protections are related to those?
Yeah, you bring up a great point. When people say they're copywriting something, that's a little bit of a misnomer because the Copyright Act gives you protections in the work the second you put it into any tangible means of expression. So the second I write it down on a piece of paper, the second I pull up my iPhone's voice memo app and I record it, I have a copyright in that work that I created. Where we get those additional protections is when we federally register it with the U.S. Copyright Office. And there you get plenty of good things. And it's pretty affordable. You go to copyright.gov, go to the Electronic Copyright Office, which is eco.copyright.gov. And there you get the right to sue. You can't bring a copyright infringement lawsuit until you've actually registered a work and it's been accepted. So that gets you in the door for a copyright lawsuit. You get the right to collect your attorney's fees and statutory damages, which can be very beneficial if somebody stole your work but didn't necessarily make a lot of money off of it. It's easier to show a work makes money if some big artist steals it and it's successful. It's going to be a lot harder to get those damages, those actual damages, if it's some local person bootlegging. So statutory damages, also very important. And then it also gives you a presumption of ownership. From the date that you register, you are presumed to be the owner of that work. So if you go into court, there's not even going to be a fight over like who is the owner because you are given that presumption. They can always counter that, but you start from the place of it's assumed and presumed that you're the owner. So plenty of good protections that you can get through federally registering the copyright.
Yeah, lots of great protections. And then I've read that there's a sound recording part to it and a performing arts part to it. Could you talk a little bit more to those?
Absolutely. So the music business really revolves around two separate copyrights. You've got the composition copyright, that is your music and lyrics, and is what people usually refer to as publishing. That is, your song lyrics, your melodies that you write, your top line melody, all of that. That's your composition. And you can sell that in sheet music that can collect mechanical royalties, that can collect your performance rights organizations like your BMI and ASCAP that's going to pay out on the royalties from the composition. That's one whole side of the copyright. The other side of the copyright is your sound recording. And that's also known in the industry as your master. And that's a completely separate copyright. So somebody could write the music and lyrics and somebody else could record the song and they could be separate owners of the respective copyrights.
Okay. One thing that I had also read about is a group of unpublished works, and in a way that you can copyright both of those at the same time. If you register something like, what is the max, 10? I believe it's 10 now.
But the max is 10. You can register up to 10 batches of unpublished works. That can be sound recording, that can be a composition, that can be a combination of two in the same application if you are the owner of both, or you and your writing partners equally own both. So if you are a solo singer songwriter, you write all your songs, you also own 100% of the sound recording, then you can register up to 10 unpublished songs at a time. Definitely worthwhile. It's also batching it is going to be beneficial for you because every time you file with the Copyright Office, it's $65 application fee. And they don't care whether you file one song at a time or you file 10 songs in the case of unpublished, or up to 20 songs in the case of a published album. So, you can save yourself some money if you start batching those applications.
So to confirm for the folks at UMD, so if I have 5 songs that I wrote myself, the musical productions and recordings of those songs, and then I have 5 songs I worked with somebody else, I would have to do 2 separate batch copyright registrations for those, correct?
Absolutely. Yeah. You could, if you wrote the song yourself, but you co-own the sound recording, then you would do a batch of composition copyrights, and then you do a batch of sound recording copyrights because they have different authors.
Okay. Now, another thing that I've read, so obviously I've done some digging, not nearly as knowledgeable as Ryan here, so listen to him for the source, but I've been on countless blogs, one of them Reddit. There's a lot of people talking about if you sign up with a PRO or you have a distributor, specifically the distributor, if you put your songs out for distribution, where they send it in places like Spotify, Apple Music, all that stuff, that your music is copyright protected there, that they do the copyright for you. Now, is that a correct thing, or is that people are trying to think that they cover themselves by going through the distributor, but they're not actually doing any legal protections for you in that process?
Yes, the distributor is not the same as taking that legal step to federally register with the Copyright Office. So I talk to artists all the time that say, I own the copyright, I registered it with DistroKid, and I also registered it with BMI. There we go. Those are completely separate processes. And again, you still have the copyright from the second you put it into any tangible means, but there's a difference between these different functions. Me sending it to my distributor to put it up on the DSPs is just that. I am just sending it to offer for sale and stream. That doesn't give me any additional legal protections in that work.
So along those lines, for those that don't know, BMI would be the PRO and DistroKid would be the distributor.
Yes, BMI would be a PRO, as well as ASCAP in the United States. And then the distributor could be any number of different companies: DistroKid, TuneCore, Two Lost, AWOL. I mean, there's millions of them.
Yeah, see, all of these things that you might actually want to spend some time with an entertainment attorney to understand in full. So the next thing I was going to ask is it better to register before or after publication? So publication being that you've put out those works for some type of sale or distribution to the public. Should I register before or after I take that step?
I don't know if there's a better. It really comes down to your level of risk tolerance and what your concerns are. I usually wait until the work is completed and published, just because now I'm registering this actual album instead of a group of unpublished works. So for me, keeping track of it and making sure that I released this album on this date, this is the name. I find that that's easier for me. But if you are concerned that somebody might be taking that, especially if you haven't publicly released it for sale or stream, but you're out there touring and playing it, maybe it is something that you want to register.
Yeah, touring it or sending it to studios or producers or mixing, any types of those situations. I know a lot of folks that don't do that, but it is, like you said, it's a risk tolerance and a personal preference in that situation. And one other thing with registering after publication is that the official songs that you're putting out there, the sound recording protections for those are the masters, correct? So it
Yes,
wouldn't be
that's
some kind of draft version that you do with a group of unpublished works unless you've done an official recording already.
Yes, that's a great point. If you are waiting till you it's published, now you are getting protection in the actual sound recording that you've put out to the public, as well as that underlying composition. Because it's not going to do you a whole lot of good if you have registered a voice memo and you've got that sound recording, but somebody samples your actual finished album version, because they're two different copyrights.
Yeah, that makes a lot of sense. I correct me if I'm wrong, but I believe that that's the way that publishers in the industry work when they're working with major label artists. At least I know for Ed Sheeran because I went to the copyright office and looked up Ed Sheeran's publishing for the songs that he's come out, and it tends to be after the date of publication where they go and register the full copyright.
Yeah, that's typically what the major companies do. The labels will register it around or after it's actually been released. And publishing companies won't even bother registering the composition unless it's something that is doing well and takes off. Because if you hire or you're under contract with a publishing company and you're a staff songwriter, you could write 50 songs a week. They're not concerned about every single song that every single writer sends to them. They're concerned about the songs that actually get picked up and placed with a major artist.
Yeah, and that makes a great point because a lot of the folks that, work with the UMD channel or that come to the UMD channel are home recording artists, and they might have lots of songs under their belt. Like I had talked with you right before this interview. I probably have 100 songs. Maybe 20 of them are full finished songs ready to be recorded, and then another 80 where it's at least a couple verses and a chorus. And you're always thinking like, how can I protect myself with these songs if I want to share it with friends, if I want to share it with other collaborations with other artists? And it seems like it's always going to be a game of risk tolerance. Always, how much do you want to protect yourself up front, and what are the actual risks to sharing your music with those folks before anything actually happens? And then one thing that I've seen that deter a lot of people, again, this is from multiple Reddit conversations that I picked up, but is the fact that some people don't bother registering their copyright because they don't feel like they have enough money to actually go to court and sue. And just for the fee itself, for the $65 I believe you mentioned for that group of unpublished works, that's not too difficult. That's $650 a song in that case if you do 10. But should that be something that deters people from going this process? Because if it's a blatant case of copyright infringement, would a lawyer sit down with them and at least help them decide if it's worth pursuing and going forward with?
Absolutely. So I think if you have registered a song before it gets stolen, then you do get those protections like the statutory damages and the right to collect your attorney's fees. Each law firm is going to handle that differently. But if it's a really, really good case and kind of a, slam dunk case, it's clear that somebody stole your sound recording and they stole your lyrics. If you've registered it before the copyright infringement, you're likely going to be able to find a copyright litigation firm that takes that case on a contingency and only gets paid when the case is won and you get paid, because you've got those rights to attorney's fees. But that only is going to apply if you've registered it before some type of infringing act. So I think that copyright registration with a $65 application is pretty cheap insurance in case anything ever happens. And I'm not saying go out and register every single song you've ever written, especially if it's unpublished. Some people have hundreds and thousands of songs, and that's going to be cost prohibitive. But if you've released music, I think it's totally reasonable to get your albums and your EPs and maybe your singles registered and spend a couple $100 and feel, confident that if something were to happen in the future, you're going to be protected.
Now, can you retroactively register your copyrights? Like, I posted a song maybe 10 years ago, and I don't know how it's doing or what's going on with it, but could I actually take that and go to the copyright website, the eco.copyright.gov, and register that work 10 years later?
You can always register it, and the date of registration is still going to be the date that you file the application and it gets accepted, but you can list the publication date as whatever date it actually came out. So you're going to have those federal protections from the date of the application. You can always go back and say this album came out 10 years ago. So that kind of prevents some maneuvering. That prevents a litigant from saying somebody stole my song 3 years ago. It was never registered, but I technically came out with it 10 years ago. Let's file this now and kind of undo that process. You're still going to have the date that you filed as the date, but the date of publication will also be on public record.
Now, a lot of people think that because computers can timestamp, the files of your recordings, like your DAW recordings have a timestamp, that if it ever came to needing to go to court, you can just show that in a court of law and, bing, boom, done, you won the case. But I know one, as you mentioned earlier, in order to even go to court for that, you have to have a registered copyright for that work. And can you also explain maybe some court decisions that have maybe deterred people from doing that, or that doesn't hold up?
Well, it's nothing in anything that you do in these things except for registration is going to be a slam dunk automatic win. I mean, metadata itself can be manipulated. It's good evidence that something was created, and you're still going to have to prove why that piece of information is what you say it is. But it is good to have. It's like people thinking that taking a copy of their album and mailing it to themselves and having it in a sealed envelope and postmarked, that's going to give them some strong copyright protection. That's considered like the poor man's copyright is the term that it's used in the music industry.
Right.
It used to be, it's kind of a myth now. It used to be something that was a lot more common, and it was cheaper than filing a federal copyright registration. But it doesn't give you any added protections, except that if something were to happen, you could go to the court and say, here's this sealed envelope, clearly shows that this record existed at least as of the date that is marked on this envelope. Again, that's going to depend on the judge themselves and if they think that that's a good argument, because you can also manipulate stamps and reseal something and whatever. I mean, the best evidence you can possibly have is that federal copyright registration,
that official registration through the Copyright Office. And that makes a lot of sense too. Coming back to that song that I had posted 10 years ago or more now, 15 or so. Not trying to show my age or anything, but does posting a song to YouTube constitute as an official publication of that song?
Yes. Any time where you make it available publicly, you have published it. It doesn't have to be there's no requirement that has to be offered for sale for it to be published. You've just made it publicly available. So yes, I do believe that YouTube is a publication.
Okay, so just keep that in mind, guys, because a lot of us are working our own YouTube channels, our own artist channels. And when you go and post something there, it can be considered, and most likely is considered, an official publication of that work. So if it's an original work that you want copyright protections, you want these legal protections, then you should go ahead and copyright today. Again, it's all based on your risk tolerance, and it's all based on, if you're pumping out like a song a week and you've got 50 songs, you have to kind of decide, what is your risk tolerance with any of these songs? And in your mind, what is the likelihood that somebody's going to, pull these? Are you a small channel or are you a large channel? But that almost doesn't even matter because anybody can come to your YouTube channel at any time. So if you want to be protected, always keep in mind for the official copyright.
And it also depends on what version you're sharing to YouTube, right? If you are doing a setup like you've got right now and you're making a YouTube video, you are obviously you're publishing the composition because that's the song and lyrics, and you're publishing at least the recorded version as it exists when you're performing it right then and there. If you're publishing a music video or a lyric video or something that's like the official audio, that's something that's separate and that you should also consider.
So then you would essentially have to register for copyright that master that you've tied to that music video, separate from that live version that I had done in a previous video.
If you want to have protections in that recorded version, yes.
Okay. Yeah, that's good to know.
Most people don't. I'll say it's rare that people get that nuanced with it and federally register like their YouTube clips and those performances.
Right.
The studio version, the mastered version that you're putting out on the DSPs, and the composition are going to protect you in the vast majority of situations that may arise.
Okay. And I actually had one question with the group of unpublished works. If you register 10 at a time, I know we're going way back now, but if you register 10 at a time and somebody infringes on one of those works, does that mean that you can't go after the same person or somebody else if there's infringement on another work because you've already done it for that group?
No, each act of infringement stands alone,
Okay.
especially if we're talking about different infringers, that they're completely separate events, even if the body of work happens to be the same.
Okay. And would that be the same if it's the same infringer on two separate pieces of work from that group of unpublished works?
Yes, the Copyright Act says that each act of infringement is separately you'd be separately liable for each act of infringement. What that would look like if you were suing one person who was using two different songs, like logistically, is you'd probably sue them in one lawsuit for two different violations.
That makes a lot of sense. Okay, so now I think we should bring a little bit to some Q&As. So I'm going to pull up this view and get my Q&As up. So we had a couple questions come in from the UMD email list. And if you're not on that list already, I'm going to put a link in the description below so that you can sign up. I basically inform folks about new videos, give specific blog posts that you won't get in a video if you just come to the YouTube channel. So that's a little added content. And then I'll send out questionnaires or different types of topics or useful things like the sample packs that I'm using and where I get certain sounds and little tidbits that you don't necessarily get from these videos. So definitely sign up for that email list. But for the Q&As that we got a few folks coming in. The first one is, what is the minimal process for copyright protection of a song? And I think that we had covered that earlier, where that's going to the eco.copyright.gov and registering whatever work you have in a tangible form to get that copyright protection, kind of get the ball rolling.
Yeah, I can put some meat on the bones there. You can create an account with the Electronic Copyright Office. You register an account, you log in. On the far left side, there's a start application. Depending on what you want to register, you can either register a work of performing arts or a sound recording. Work of performing arts is usually the what you'd register for just a composition. If you're registering both the sound recording and the music and lyrics, you can register as a sound recording, but don't make this mistake. There was a recent lawsuit against Childish Gambino where they said it was a copyright infringement. This author had done a group of unpublished works in sound recordings, but he alleges that there was no violation of the actual sound recordings, it was the compositions. When you want to add both, there's a section right after you add your authors to say what they contributed. And there's a little checkbox. And you can either just do the sound recording or you can click a checkbox and they give you, examples of what to add. But you have a little checkbox and you type in lyrics and music. If the owner is 100% the same on both the composition and the sound recording, you've now registered for both the sound recording and the composition. That one little mistake cost that guy a major copyright infringement lawsuit.
Perfect. Thank you for that warning. I almost think it might be a good idea to put a little tutorial out on how to go through that process of registering a copyright. If you guys are interested in that, let me know in the comments below. I can see if I can walk you through that situation, at least up to certain points, and maybe talk to you at least about some of the screens to get you going. Another question that we got was, how do we know if a newly written song was not written before, at least enough to qualify as it was, enough of the same tune to be legally sued?
Great. It's a great point. There is a saying in intellectual property that there is nothing new under the sun. What I tell artists and songwriters is that the copyright only protects your original expression of an idea, but not the idea itself. So let's take like a Romeo and Juliet situation. Nobody can own the idea of, boy meets girl, boy falls in love, like tragedy ensues, right?
Right.
But it's how that story and those characters are written, the actual expression of that story that is protected. It's not protected anymore because it's so old, but that's kind of the point. If you have just an idea of a song, somebody likes, it's about summer, it's about hanging with your friends, and these are the good old days. That's just an idea. But if you rip verbatim, the lyrics to Sweet Home Alabama, now we're talking about copyright infringement or the melody or something like that. So those are the differences there, the idea versus expression. But the other thing to keep in mind is there's such thing as subjective, subconscious copyright infringement, even as unintentional. And that's what happened with George Harrison with the song My Sweet Lord and He's So Fine. That He's So Fine, very popular girl group song, from the 60s. If you listen to the two songs, George Harrison's song came out after the melody, the chord structure, everything is identical, even the syllables that he uses. But he says, I didn't mean to, I didn't even think about that song.
Right.
It said if a song is big enough and popular enough, you are deemed to have known that it existed, and he knew that it existed. And you can copy something subconsciously without even meaning to. So if somebody says something like, oh man, I really like that song, but it sounds just like Tom Petty's Free Falling.
Oh, you're in trouble.
Maybe you should change it up a little bit.
Tom Petty has a good winning streak too. He got Sam Smith on that one.
Absolutely. So that's my advice on that.
Yeah. I mean, you brought up a great point. I think even, don't quote me on it, but I think even Ed Sheeran's Photograph, there was, I don't know if it's Britain's Got Talent or some talent show where somebody basically has the exact same melody as the chorus of Photograph, but at least that got settled kind of outside of a court of law and everyone was able to move on. The more recent Ed Sheeran case where he proved that Thinking Out Loud, I believe it was, Marvin Gaye's family had come and sued him because of the style and the sound, and then he proved in the court of law that there were hundreds of songs that have similar styles and sounds, chord progressions, and even showed a bunch of songs that came up before Marvin Gaye's song. So I wish I could say this stuff is black and white. I think a lot of people wish it was, but at the same time, that's coming from a perspective of music and arts being black and white, and it never is. So when it comes to the legality of it, in order to protect yourself, in order to be protected, or whoever you're working with to be protected, it's kind of good to have a range of ways to see in certain circumstances, is this actually copyright infringement or not? It's not all one size fits all, like Ryan had mentioned earlier. And I think we have time for one more question.
All right.
And this one was, at what point, so we had talked about this a little bit earlier, but if we have any extra tidbits for it. So at what point should I copyright a song? Does it have to be the final version? And what if I make a few changes to the notes or words, but it's mostly the same? So copyrighting the song, we had talked about, your comfort level and before or after publication. Does it have to be the final version? Of course not. But now here's the caveat that we should touch upon in this question is, what if I made some changes after the official copyright of the initial song? Should I go and copyright those changes or the song again?
Yeah, you can always copyright a new version. Depending on how much it's changed, you might have created a derivative work of the original, or you might have just changed a line here and there. You can always register multiple versions of different songs. And, if that's something that you think it's changed enough that it wouldn't be covered under that original registration, then definitely do that.
All right. Well, thanks. One piece of advice, and again, not a lawyer, but one thing that you've seen, at least with Taylor Swift's case, is if you have any ability, the more ownership you have in your own works, even if you're working with a PRO or a publishing company or a label, the more ownership you have in your own works, the more ways you can be protected and the more that you can use those works in the ways that you'd like to versus what somebody else will tell you those works have to be used. So in Taylor Swift's case, she was actually able to re-record dozens of her songs, even though the label had owned copyrights on those because she owned the copyrights to the she owned the copyrights to the musical composition while the labels had the master recordings. So she just re-recorded her own master recordings and re-released those songs, and guess what? Topped the charts again. Amazing. All right, well, this was an amazing interview. I can't believe we crammed so much in, just the 40-minute cap that we have right now. Ryan, I want to thank you. Thank you for your time. I know that you're exceptionally busy, both working with artists in your job as well as at home with your family. And, just to have you jump on here for a call, I really hope that we get to do this again soon. I'm sure there's going to be additional questions. If you guys have more questions, post them down in the comments below, either for a future conversation with Ryan or for a future discussion on the channel. I'll also send out another survey after this video so that you guys can also submit questions that way. And then I also want you guys to know that if you want to get in contact with Ryan, Ryan's on Instagram at ryanschmidt.esq. So Ryan Schmidt Esquire. That's RyanSchmidt.esq. And I'll put the link in the description below. And then you can also go to the website of his entertainment attorney firm, which is bowenschmidt.com, BOWENSCHMIDT.com. So thanks for joining the Ultimate Mixdown. Thank you, Ryan.
Thanks
this was amazing.
Likewise.